I formally welcome you with a very warm good morning. And today we are going to discuss, deliberate, and delineate some of the important aspects of international refugee law, and particularly the protection of refugees. Today I propose, my dear friends, the principle of refugee and migration or migrants protection under the global compacts on refugees and migration. At the same time, we are also going to evaluate the protection thresholds, degrees, limitations, and demarcations which are available to all of us, particularly refugees, under international human rights law, international humanitarian law, international constitutional law, and the role of international institutions, organizations, societies, and to what extent refugees themselves have become the voice for their decision making or the decisions which are being taken at the institutional level, at the governmental level, at the national level, at international level, and how these decisions have been affecting, influencing, and impacting the protection of refugees in different manners. So this is going to be our brief of this engagement, and I formally once again encourage you to put a lot of questions, because your punctuality and asking question is going to be reflected in your grading. Because when you are asking questions, basically you are going to enhance your grades. This has always been one of the most important feature. Time and again I have been submitting this particular aspect of my teaching methodology, and today also I am encouraging you, please go ahead and put a lot of questions. You not only questions, but if you are having your own ideas, you are having your own comments, observations, or any kind of an input for the enhancement or for contributing the richness of our ongoing deliberations in the area of international refugee law, you are most welcome. With these submissions, let us proceed, let us get down to business to understand the principle of refugee and migrants protection under the global compacts, as well as other important disciplines, particularly the independent disciplines of recent what we call origin, which have come to be recognized as independent specializations, like international human rights law, international humanitarian law, international constitutional law, and international or comparative constitutional law or comparative international law, and customary international law. And to what extent this entire what we call broadly, this entire what we call protection shields which have been created under these what we call disciplines, and to what extent, what I mean, when we are going to assess the legal institutional response of institutions like IRO, IOM, and UNHCR, ICRC, and other important what we call outfits of an international character, whose what we call services everybody acknowledges. My dear friends, to understand and to deliberate this deliberation, we require certain important specific legal frameworks. Frameworks like 1948 Universal Declaration of Human Rights, particularly Article 7, Article 10, Article 14, and Article 27 of the Universal Declaration of Human Rights becomes very, very important to understand the principles of refugee and migrants protection. Again, there is another important convention of 1949, four Geneva Conventions I am talking of, particularly common Article 3, and that is available in the particularly the fourth Geneva Conventions, Article 44. These two important what you call deliberations require our incisive intellectual autopsy in understanding what kind of protection is available under international humanitarian law. Then we cannot forget 1954 UN Convention relating to the status of stateless persons that we have deliberated yesterday. Then the 1961 UN Convention on the reduction of statelessness becomes again relevant. That is very much germane in understanding what kind of a protection is available to stateless people and how to reduce statelessness and other important facets of the refugee protection or migrants what we call protections. We have to take into account again, my dear friends, 1966 International Covenant of Economic, Social and Cultural Rights, then 1966 International Covenant on Civil and Political Rights, then we have to undertake 1967 United Nations Declaration on Territorial Asylum, then 1977 Additional Protocol Second governing non-international armed conflict, and this is a additional protocol to 1949 four Geneva Conventions. That is the subject matter of international humanitarian law. Then we should also take into account, my dear friends, 1989 second optional protocol to the international covenant on civil and political rights, where we find, and this particular second protocol has contemplated and envisioned, my dear friends, the abolition of the death penalty, and that came into existence, came into what we call force legally on 15th of December in 1989. So this should also be taken into consideration, my dear friends, to understand the various what we call thresholds of our understanding. At the same time, 1984 UN Convention Against Torture, 1990 UN Convention on Protection of the Rights of all migrant workers and members of their family. We have also made certain important specific references in our last what we call deliberations of this convention. The 1990 UN Convention on the Protection of family members of all kinds of migration, migrants. Then the national legislations, national laws, national policies which have been drafted, adumbrated by various what we call governments within the domestic what we call jurisdiction. Then we have to understand, my dear friends, entire what we call canvas, entire protection shield that we receive from the non-binding instruments of a legal character in the form of principles, paragraphs, declarations, and other important what we call good offices. Then we should also take into account the UN Office for the Coordination of Humanitarian Affairs, guiding principles on internal displacement. That should not be forgotten. We should also consult, and we are going to consult, my dear friends, UNHCR's handbook for the protection of IDPs, and then the UNHCR's other important what we call engagements, including 2016 New York Declaration for refugees and migrants, and 2018 UN Global Compacts on refugees and what we call migrants. That should also be taken into consideration. Here lies, after these frameworks, my dear friends, we require, and these kinds of engagement, when we are talking of the refugee protection under global compacts on refugees, migrants or migration, then or IHL or IHRL or in international comparative law, cumulatively speaking, my dear friends, there are certain important questions, and those questions must also be answered. The very first question, my dear friends, that comes to my mind is, and it's a very, very relevant question, and by asking this question, I'm intellectually and juridically agitating your faculty of reason. And the faculty of reason demands, are people illegal? It's a huge question. Under international human rights law, under international humanitarian law, particularly the common Article 3 that is common to all four Geneva Conventions of 1949. At the same time, we have to undertake and understand, my dear friends, what exactly should be the answer. Because as an individual, as a member of the civilized society, As a well-educated person, I do not have, personally speaking for myself, my dear friends, without offending anybody's sentiments. And you should not get namby-pamby on this particular issue. We do not have, cumulatively speaking, my dear friends, any contribution in our birth. So is it okay to call people illegal? Is there possibility of people being illegal? Or is it correct to call people illegal? People are not illegal. Even illegitimate child, for legal point of view, for legal purposes, should never be called as illegitimate or illegal person, because he doesn't have any kind of a say, any kind of a contribution. He has never been, or she has never been instrumental in her his birth. It Because there are some other important biological agencies which are involved in the procreation of children. That should never be forgotten. So therefore, this is my cumulative understanding, my dear friends. The people are not illegal. The second important question that comes to my mind is, what are the basic human rights? What are the basic human rights of refugees outside 1951 UN Convention relating to the status of refugees, along with its additional protocol of 1967? What are those rights? Or should we believe that some kind of this is the only, there are only two important legal instruments, legal frameworks, which can speak of rights of refugees? No, it is going to be incorrect, my dear friends. What is important is, we have to assess, we have to visit what exactly are the rights outside the Refugee Convention of Refugees. Then what is refugee status a solution to? Where the line between state sovereignty and the individual protection should be drawn? As I have submitted on earlier occasions as well, that the idea of sovereignty in the contemporary circumstances, my dear friends, where human rights has become, or have become, the barometer to make an assessment of the state behavior, to determine the thresholds of the international relations, to argue and to have some kind of understanding of diplomacy, foreign policy. All these projects must contain adequate safeguards for the protection of individuals, including refugees. And it can only be made possible by invoking certain fundamental human freedoms, certain fundamental non-derogable human rights, whereupon there is no possibility of any kind of a reservation or any kind of a preclusion. So that should always be maintained, and this is something which is very sacred and sanctimonious. Then is the notion, my dear friends, of a refugee dependent on, defined by the existence of the sovereign nation states? What is the role of international organizations, non-governmental organizations, international non-governmental organizations, my dear friends, in refugee protection, and how have they transformed the understanding and application of the refugee protection, or migrants, what we call protection? There is another ancillary, what we call question: is a successful refugee protection regime reliant on responsibility sharing by states? If so, how is responsibility sharing and state accountability to be improved or achieved, as we have been witnessing, particularly in the context of Rohingya refugees in Bangladesh, or other important new refugee groups? I am talking of the Ukrainian refugees. But Bangladesh still remains the most, what we call important country, who is hosting the largest refugee bloc at international level. So we have to take into account, because we have already shifted from burden sharing to responsibility sharing, from individual, what we call from national solidarity with that of the international solidarity with the refugee hosting nation state. And it was exclusively made possible, my dear friends, because of the 2016 New York Declaration on Refugees and Migrants, whereunder we have also received global compacts which are today known as 2018 UN Global Compacts on Refugees and Migrants. Here lies another important question, my dear friends. What are the basic human rights and what are the basic human rights of the refugees outside the 1951 UN Convention relating to the status of refugees with its additional protocol of 19 what you call 67. So how we should what you call try to understand all these facets, and these facets constitute a very important what you call milestone. How can the rights of refugees be protected under international human rights law? What is refugee status under international, and how refugee status is generally appreciated on critical footing within the or on the anvil of the international human rights law, where the line between the sovereignty and individual visible, I should say. How to define a migrant, my dear friends, and what is the legal framework of human rights protection for all migrants, and what are the, my dear friends, draft principles and practical guidance on the human rights protection of migrants, particularly I am talking of the irregular migrants, vulnerable what you call situations, and mixed and the large what you call movements of refugees that should also be taken into consideration. Let us deliberate it under international human rights law. This reminds me of a very important decision. My dear friends, the appeal chambers of the ICTY in the Tajik case specified, my dear friends, that an armed conflict to exist whenever there is a resort to armed force between states, or protracted armed violence between governmental authorities and the organized armed what we call groups. Between such groups within a state, I am talking of, my dear friends, prosecutor versus Tajik. This is a decision of 1995. With regard to the distinctions between international and non-international armed conflict, ICTY has also found that the certain norms of international armed control are applicable to non-international armed conflicts based on customary international law. And this is the point which should never be what we call, overestimated or overlooked. Therefore, my dear friends, it has to be taken into consideration when we are, talking of these what we call hostilities. My dear friends, most states today recognize some limits to their sovereignty, and at least ostensibly, I should say, acquiesce to what we call treaties and covenants designed to protect those rights. Or in other words, let me put it like this, my dear friends, that it has become a fashion, an international what we call fashion, particularly within the corridors of United Nations organizations, or where the political parties as well as the governmental what we call representatives are calling the shots. It has also become a fashion that everybody is talking of human rights. Every representative is talking of the fundamental human freedoms, civil liberties, the rights of the vulnerable sections of the society. And we have been witnessing a lot of motor mouthing. And this motor mouthing does not result at the ground level so far the real protection, I mean the ground protection of human right is concerned. Prior to the Second World War, such a concept would have been rather, I should say, would have been deemed untenable. As state sovereignty, my dear friends, remained the norm of international relations. If you take into account the gradual civilization or gradual civilizational maturity that has been achieved by the nation states after having lot of crisscross of or lot of cross fertilization of different what you call aspects, you will find that when we are talking of state sovereignty has always been something untouchable. It has always been, treated as a holy cow, and it was not at all possible to have any other subject matter of international law except, international relations, international organizations, and nation states. But in the later half of the 20th century, my dear friends, we have witnessed that there are some other important considerations which should also be taken and amalgamated within the, rubrics of the subject matter of international law. And this is something which we have witnessed, that in the later half of the 20th century, an individual, a human being, has been what we call regarded as a subject of international relations as well as international law. Therefore, states were the final arbiter in the treatment of their, citizens, and other states should refrain from intervening in their affairs. This kind of a line of argument was relegated to the background, and at the forefront, what we have been, what we call, witnessing, what has, surfaced at the, forefront, it is the majesty of individualism. It is the majesty, my dear friends, of human rights and fundamental civil liberties, and we cannot ignore, we cannot, avoid the rights of, refugees in this particular realm. I can further what we call take a cue from other important, developments in the existential history of the humanity. I'm sorry. Holocaust. Holocaust and the atrocities associated with the Nazi regime served as a catalyst for the human rights movement, while propelling the issue into the international arena. After the Nazis attempted to systematically eliminate the Jewish population, my dear friends, particularly from Europe, as well as targeting gypsies, handicapped, elderly, homosexuals, the world's response was one of the horror. It was the extermination of over 6 million people, my dear friends, by the Nazi regime that created the political will to mount the first true challenge to the idea of sovereignty with respect to human rights. International discourse at the same time, my dear friends, on the importance of human rights has continually increased since the end of the World War II. But many states continue to violate a wide range of rights, and South Asian nation states are not an exception to this kind of culpability, I should say. They have always been hobnobbing with some non-state actors, state-sponsored actors, and some other important what we call stakeholders. We have been witnessing in South Asia in the name of what we call of honor killings, in the name of caste, in the name of race, in the name of ethnicity, in the name of what we call of religion, in the name of political opinion, in the name of membership of a particular social group, in the name of ideology. We have been witnessing some kind of violations, generalized violence, massive violations of human rights in South Asia and their geopolitical entities within this what we call region. But some of the worst human rights violations have occurred in the modern times, even outside what we call of South Asia, though South Asia is also the part of the modern times. The atrocities committed by the Khmer Rouge in Cambodia, we cannot forget. The ethnic cleansing in the former Yugoslavia, the slaughter in Rwanda, the genocide in the Darfur region of the United Sudan. Now we are having the South Sudan as a new geopolitical entity on the world political map. Then the persecution of Hindus, Sikhs, Shias, Ahmadiyas, Chakmas, and Rohingyas in Afghanistan, Pakistan, Bangladesh, and Myanmar. And presumed what we call pogrom of Muslims and Christians in what we call, in some other parts of, South Asia, as well as beyond what we call, South Asia, that cannot be what we call, forgiven. Another important dimension that comes to my mind is, my dear friends, that is the, food insecurity. Lack of clean water, lack of what we call basic healthcare continues to be the everyday realities for much of the world. Another important dimension which I would like to what we call put for your consideration, that is the modern slavery. Slavery is on the rise today. In Eastern Europe and South Asia, women are trafficked as sex slaves. In the Democratic Republic of Congo, we have also been what we call witnessing children are being forced to fight in wars. And in most of the SARC region, my dear friends, particularly in India and Nepal, children are being forced to work as child labor, or in roadside what we call dhabas and eateries, or in sweet shops for subsistence wages instead of attending school. This is what we have been witnessing in our part of the world. But at the same time, my dear friends, I must highlight another important development. Ever since this is the 27th or 28th day of Russian attack on Ukraine, I may be incorrect in my construction of language or in my semantics, but we should not forget this particular reality, that countries like Israel, they have been what we call accepting some of the refugees of Jewish origin under its law of return. But at the same time, what we have been what we collaterally witnessing, I should say, that some women of Ukrainian origin, they are being what we call despite being their Jewish what we call affiliations in the past, or Jewish origin, they are being what we call pushed in prostitution in the state of Israel. And they are also minting money if non-Jewish populations are knocking the doors of the state of Israel, because they have what we call demarcated a quota system they came out with, and now they are accepting non-Jewish population, and they have determined only 5,000 individuals would be accepted as what we call refugees. But for them, they have determined for their what we call hosting some amount of what we call of dollars, and they have to pay for 3 months or 4 months or 6 months for their stay in the state of Israel, and thereafter they would be repatriated back to their country of origin. So this is how the human trafficking, as well as what we call people have been, nation states have been making money out of what we call of the human rights miseries. On the other hand, my dear friends, many people, the lack of human rights is a daily reality, while citizens in parts of the world are experiencing greatest respect for human rights, or the greater amount of what we call of respect for human rights. The majority have yet to realize and enjoy the full spectrum of human rights in many important what we call geopolitical entities, and this is something we have also been witnessing in many parts of the world. The disjuncture, my dear friends, between the discourse on human rights and the realization of human rights is one of the important paradoxes of the study of human rights in the context of what we call of the refugee protection. And this is something that becomes, and that also provides some kind of a what we call of idea of research on these what we call gaps. But at this stage, my dear friends, particularly, we are not alone as members of the faculty of legal studies, but we are also having other friends as well. And that is why at this stage, I would like to what we call inject a juridical as well as a jurisprudential what we call understanding of a universal idea, and we know that idea is human right. My friends from Faculty of Legal Studies are well equipped in understanding the different nuances of human rights. But the student of sociology, the student of international relations, and other disciplines are having a different what we call perspective from a legal point of view, from a sociological point of view, from a interdisciplinary point of view, including what we call jurisprudential what we call understanding of this universal idea becomes very, very important. And that is why I invite your special attention, particularly my friends from other faculties, from other departments. My dear friends, the concept of human right is not new. You are all well acquainted with this. Many states and communities have been established on this particular idea. This is an idea that has also been regulating international relations, foreign policy, diplomacy, as well as what we call, bilateral relations, trilateral relations, multilateral relations, and unilateral understandings as well. Even human rights have also become to govern, that has become some kind of a, anvil where even the state behavior is also, assessed. The individual members have certain inherent rights which must be respected by those, governing. That has also become one of the finest aspects to determine the domestic what we call, well-being, or the, governmental commitment of the state what we call, commitment with that of, human rights. And that should also be reflected in its behavior towards its own citizens. My dear friends, the idea of human rights may be based on religions, or religious, political, or moral, or social grounds, I should say. And it is a mistake to assume that it owes its, origin to any one particular doctrine, one particular what we call, dogma, one particular, theory of, or one particular, governance architecture. No. Rather, human rights are best understood as a common and unifying expression of all peoples' deepest aspirations to live freely and securely in a just and and peaceful, exclusively based on transcendental institutionalism. This is something, if you recall, particularly the faculty of legal studies, members may recall this particular, line of argument. It is basically the institutionalism that must be, reflected in the behavior of the state, because everything has been institutionalized and constitutionally created institutions, and institutionalization is under attack in the contemporary what we call, political order in many geopolitical entities. Therefore, the human rights as a natural response to the violence, a natural response to repression, a natural response to the acute what we call, servitude or poverty and insecurity that plague the world we live in, that should also be taken into considerations, without which it is very difficult to understand the idea of what we call of, human rights, or idea of understanding what exactly is the right, or what kind of a, right, human right we have been, professing. Therefore, it is very, very important. Having said all these, dimensions, having made all these kinds of, submissions on my part, my dear friends, let us try to understand the nature of migration movements. There are, some large movements. When I am using the word large movements, I am also talking of, in that very largeness, we are also having some kind of a mixture, or the mixed what we call, movements. And that has generated a lot of, vulnerabilities. Within the context of many migration movements, my dear friends, a diverse group of people move together and often share the same risk of human rights violations. And this is what we have been, witnessing. But for the first time, my dear friends, at this stage of my maturity, what I have been, witnessing, though this is not new, but that has really jolted me from inside. And that is the, situation which I have, witnessed visually on television, on DW, on CNN, on Sky News, on France 24. For the first time, I have, witnessed this kind of a situation. There was a live what we call, telecast from the, Ukrainian international borders in the neighborhood, particularly Polish and Ukraine, what we call, international borders, Moldova's, international borders, and Slovakia's, international borders between Ukraine and Slovakia. From this particular, side of, borders where the Ukrainian refugees were, entering into and crossing into neighborhood, what we call, nation states. So we have witnessed that racial discrimination was at the forefront. Even the refugees, the Ukrainian refugees, as well as the, law enforcement agencies and the border, what we call, checks officials, they were also what you call pushing Africans, blacks, and brown, what you call, complexions, people, they are being pushed aside, and the passage was what you call, given to the white people. So in this particular, what you call, movement, I have witnessed the elements of racism, and elements of racism guided by, supremacist tendencies of the white people. So that is another important aspect, and that should not be forgotten, because many people on the move today fall outside established legal categories, or fall in and out of the categories, but are nonetheless in the need of specific protection interventions. But what about the what is the fate? What is the I mean the crime of those very people who are not what we call white, and they are stranded and sandwiched in these kinds of large movements, or mixed what we call movements. My dear friends, on many occasions, the people compelled, or people are compelled to move in large scale. Irregular and precarious what we call movements are particularly at risk of harm. And who is going to what we call address this kind of a situation? That still remains to be what we call addressed, or to some extent when it has been addressed, but the address has not trickled down to the ground, and ultimately sufferers further what you call suffer, and the situations are getting gradually and gradually more what you call aggravated. So this kind of a situation must also be taken into consideration. So when we take into account migrants in vulnerable what you call situations, as I have given an example of the Ukrainian refugees, therefore when we take into account the migrants and their vulnerabilities, my dear friends, so, and what kind of a vulnerable situations we have been witnessing so far, the migrants and their movement is concerned, my dear friends, migrants can be at risk of human rights violations due to the conditions they face in countries of what we call of origin, which compel them to move, and to which they may not be what we call and there is no possibility, or subsequently they would never be in a position to get back to their country of origin. Migrants can be at risk of human rights violations. At the same time, as a result of the circumstances they generally confront in their country of origin, or in their country of what we call of route, or the during the transition. Structural contexts are diverse, and inherent vulnerabilities can lead to what we call intersectional risk. For example, children. Sometimes the children are left what we call unattended. Sometimes they are abandoned because of the circumstances. Sometimes during the what we call flight, unplanned what we call flight on foot, the people and their children generally what we call got separated or get separated. So in such kind of journeys, these kinds of journeys are very long, dangerous, and often multi-directional, and some may even, or rather I should say, some may never what you call reach their intended destinations, and this is something we have also been witnessing. But at the same time, destination is not at all free from any kind of a risks. People or the migrants have also been what you call confronting risks at their what you call destination. So here lies another important question, and let me answer, though you already understand this line of argument of mine, and you will definitely critically appreciate if I ask you a question: why do people move? My dear friends, people move in the context of what we call of migration movements. We should try to understand the nature of this kind of movement. People move because of the livelihood. It means I'm talking of the economic opportunities. People move. People also move because of the food, water, and security, poverty. People also move, my dear friends, to access healthcare, education. People also move to save their lives from violence, exploitation, discrimination, stigma, prejudice, persecution, war, conflict. But today, people are also moving, my dear friends, because of the climate change, because of the natural disasters, and because of the family reunification. People are also being moved on some other important considerations. People are also moved because of the honor killings. People also move, my dear friends, because of the communal rights, racial rights, linguistic rights. People also move because of the political opinion. People also move, my dear friends, they also leave their habitual residence. People are also getting uprooted because of their what you call membership of a particular social group. Therefore, migrants who move out of necessity rather than free choice are often, my dear friends, unable to formulate exit what we call strategies when migration doesn't go to plan. Let me what you call give you few important what you call situations, some important examples. Suppose barriers to migration and lack, particularly the paucity or the lack of safe pathways. We have been witnessing at international borders, at national borders, punitive border control measures. They violate Article 33, subclause 1 of 1951 Convention relating to the status of refugees. We witness punishing and crushing border control measures. We have also been witnessing dangerous interception practices which are generally what we call used by the international border management or the law enforcement agencies or immigration officials at the borders. We have also been witnessing, my dear friends, the criminalization of migration, particularly of irregular migration. We have also been confronting, or the migration or migrants are also facing mandatory detention policies pursued by various what we call national identities or national governments. We are also what we call witnessing, my dear friends, unsustainable written policies and violence and exploitations. Basically, I should say, cumulatively speaking, in a one single word, we can put it like this: that today's circumstances and today's idea of nationalism has also created not only the borders, but we are living in an age of walls. Turkey has constructed walls on its international borders. We are also having a wall of accession or wall of segregation in the case of what we call of state of Israel. We have also been witnessing some other important walls in the Latin American nation states. Even the Trump administration has also promised, and to a great extent this wall has also been constructed along the borders between Mexico and United States of America. Though the considerations may be different, arguments may also be different, but at the same time we cannot what we call deny the reality. We cannot what we call shut our eyes from these particular ground realities, that there are walls, and these walls are nothing but the violations of some of the fundamental principles enunciated under Article 38 and its subclauses of the statutes of the International Court of Justice, which basically what we call evaluates and also contributes in the enrichment of the customary international law. So that cannot be what we call forgotten, and this is a reality which should also be taken into consideration when we are talking of this kind of a situation. So my dear friends, it has continuously, it has been witnessing, or we have been witnessing this sorry state of affairs. Today there is a requirement in the sense, my dear friends, we should have borders like there are novel ideas, innovative ideas of the border control. And this reminds me of one of the most important understanding which we have been witnessing in the Treaty of Schengen of 1985. The border which is being managed by the government of Canada on one side and the government of what we call of the United States of America, I mean the international borders between Canada and United States of America. I can also give you an example of the border control from South Asia. We are also having an open border policy between the Democratic Republic of Nepal and the Democratic Republic of India. These are the two important, nation states in South Asia where we have also been, witnessing a very, very important friendly what you call border mechanism, border control mechanism. I'm not talking of the specific, issues between India and Nepal. I'm not at all talking of, blockade or some other measures which have been, taken in the past on the borders from, both sides of what you call of, borders. But what is important in the larger interest for the last more than what you call, 7 decades or the 6 decades, we have been what you call, witnessing a situation which I can brand as a hunky-dory what you call, situation. So far, the border control is concerned between Nepal and India. And now we are also witnessing, my dear friends, under the Treaty of Schengen of 1985. For the first time, only the 13 European nation states entered into have become the part of this kind of a treaty arrangement. So, and one of the slogans, even of South Asian University, whenever you visit the website of the South Asian University, you will also find education sans borders. That kind of a what you call, slogan is there. Or the borders. That should also be taken into consideration. Now, if we are going to study, then we require, my dear friends, international legal protection framework, as I have already submitted for your considerations. We require international law. We also require, when we are talking about the international legal protection framework for migrants and refugees, we require international humanitarian law, international human rights law, law of the sea, or any kind of international maritime law. We should also have the human convention and transnational organized what we call crimes and additional protocols to this particular convention and human convention statelessness and international convention on the rights of all migrants and the members of their family and international what we call labor law. Some of the important conventions which have also been adopted by the auspices of the oldest international organizations, that is the International Labour Organization, that should also be taken into considerations. And as I have been submitted, there are as many as 9 core international international human rights treaties, and certain fundamental principles have also been recognized under these what we call core 9 international human rights treaties. Therefore, obligations which emanate from these 9 core international human rights treaties are equally relevant for the protection of refugees and migrants. Therefore, my dear friends, international legal framework.
Excuse me, sir. Sir, we can't hear you properly. There is some net issue.
More precisely speaking, my dear friends, for more precise understanding of the human rights standards for migrants in large movements, as well as how states and other political stakeholders can operationalize these political standards is something which is lacking and very required further institutionalization, further constitutionalization within the domestic jurisdictions. There is a need of a particular understanding of the protection that's experienced by migrants who will not benefit from refugee protection, nonetheless are not moving, my dear friends, voluntarily and or in a protected what we call they also require human rights what we call protections, despite the fact that their movements are not generally taken for granted as what we call the refugee movements. So there are certain principles and practical what we call human rights protection.
Your voice is cracking.
Let me understand without prejudice to the specific rights of
Excuse me, can you hear me?
Convention.
So there is an issue with your net.
Including or embedded in derived directly from international human rights law standards and related bodies of law. Designed states might be friends and other stakeholders to develop, strengthen, implement, and monitor measures to work groups on human rights and gender equality that should also be taken into consideration. My dear friends, the draft set of 15 principles that are derived from international human rights law and related what we call, or ancillary standards must be taken into consideration. Each principle is followed by a set of related principles interactions to be the legal obligations inherent in the principle, thereby address protection gaps which have been witnessed by these, migrants. So they are not, refugees, but they find themselves in refugee-like situations. Also, to be included in a framework is reference to the existing rules that have been developed by the what you call, I mean, group of, highly empowered what you call individuals or group of very eminent what you call people. 15 principles are there, as I have, talked about. You can write, and you can ask what are those fundamental principles which have been identified by the various stakeholders within the units of international legal professional framework. Number one is, my friends, non-discrimination, access to what you call, justice, protection of life and liberty, governance of the international, borders, including non-reform, lawful returns, and there has to be some kind of a lawful return as it has been initiated within the understanding that is reflected under Article 15, Article 14, and other important provisions of the Universal Declaration of Human Rights. The children in the context of migration requires the special attention and protection, and at the same time, another important, the principle number 6 or 7, yes, it is 7. The protection by the friends of violence and abuse exploitation must also be taken into consideration. Principle number 8, human rights of all migrant women must also be respected, right to health, decent what we call, work, right to liberty, adequate standard what we call of living, right to education, and this aggregated what we call, data and documentation must also be taken into consideration. And the last thing, my dear friends, some partnerships and cooperations that is reflected in the what we call adoption in 2018 UN Complex on Refugees and Migrants, which has been what we call, initiated earlier by the Obama administration. On one side, so far the political argument was concerned, and on the other side, it was collaboration between the stakeholders on one side, and the top of it happens to be the United Nations High Commissioner for refugees. They came out with a novel what we call idea that was reflected in the 2016 New York Declaration on Refugees and Migrants, and the same declaration in 2017 was also further advocated at Baku, and that is also known as the Baku Declaration. So these are some of the important fundamental principles which must also be reflected by dealing with the migrants and invoking some of the provisions of the international legal framework. I can also give you certain important examples for non-crystallization of my line of submission, and that is suppose, for example, there is on the basis of what we call these 15 principles which have been what we called out of what we call the 9 international human rights treaties, as well as 1951 UN Convention on status of refugees, and initially what I have been presenting today in the form of what we call legal frameworks which require to protect refugees and migrants. Please,
Sir, sorry to intervene.
you are saying something strong, sir.
Sir, I think, sir, we are not able to hear you properly. I think, sir, there is a net issue from your side, I believe.
Am I audible to you now?
Sir,
Your
like,
voice takes
yeah.
in between.
Hello? Am I
Sir,
audible now?
sir, your voice is breaking in between.
So, is it still breaking?
Yes, sir.
Okay. So, I will have to reconnect. Just a moment, please. Let me, reconnect. I'm sorry for this, disturbance. Hello, welcome back.
Yes, sir, we can hear you now.
Yes, sir.
Yeah, thank you. And I am extremely sorry for this disturbance. However, it was beyond my control.
Sir, this was act of God.
Thank you. Thank you for your sense of camaraderie. I was making a submission regarding certain important examples. How to crystallize, operationalize, how to functionalize, what should be the modus operandi when we try to invoke certain important principles in reality. Am I audible to you now?
Yes, sir.
Yeah,
Yes, sir.
thank you. Suppose there is a principle which I have mentioned, and I am taking it out of 15 principles. Principle is that there should be the protection of lives and ensuring the safety of all migrants in transit or during transition. And we must ensure the rescue and immediate assistance to all migrants in distress. This is the fundamental normative understanding. This is the substantive principle. How to operationalize it? My dear friends, when we are talking of the practical guidance, when we are talking of having certain measures for the operationalization, for the implementation and enforcement of this kind of a principle, what is required? We must try to establish, operate and maintain adequate, effective and disability, age and gender responsive rescue services at all international borders, including search and rescue at sea services in coastal or littoral states. That is requirement number one in terms of what we call of the practicality. We should also to operationalize and implement this principle, how to ensure the safety, liberty, as well as what we call the dignity of the migrants in transition or during or in transit. We must try to provide assistance without a discrimination and in a culturally appropriate manner to all migrants in large what we call movements or mixed movements, including, my dear friends, medical care, adequate food and water, blankets, clothing, sanitary items, and opportunity to rest. At the same time, my dear friends, again, we must implement agreements with the national protection bodies and other relevant what we call actors to ensure timely and effective what we call referrals for migrants in particular situations of vulnerability. We are also supposed to put in place measures to respond to the special needs of the children, whether they are what we call traveling alone or with what we call their family members, or they have been placed under the guardianship of some of the important people. So their safety must also be taken into considerations. I can give you another important example. The principle is, my dear friends, so for example, we have to uphold the rights of all migrants to liberty through making targeted efforts to end immigration detention of migrants. Never detain migrant children on account of their migration status or that of their parents. This is the principle. Then how it should be implemented in practicality? It requires the establishment, and we have to establish a presumption, my dear friends, against immigration detention in law. We have to ensure the international body or international what we call actors under the law have to ensure that administrative detention is only ordered as a measure of last resort, and that the reasons for this kind of a detention are clearly defined in law, of limited scope and duration, necessary and proportionate. And at the same time, the reasons for such a detention are clearly explained to the migrants. Without their information, my dear friends, we should not detain them. At the same time, my dear friends, for the sake of enforcing the principle of non-detention for immigration purposes of all children, regardless of their status or the status of their parents, we have to develop national plans to end immigration detention and to implement human rights based, what you call, or rather I should say, human rights induced or human rights compliant, what you call, compliant mechanisms and non-custodial community-based alternatives to what you call, detention. And we have to provide guidance on the best, what you call, practices of temporary reception facilities in order to uphold the rights to liberty and avoid unnecessary detention. This is how we can, what you call, uphold these kinds of, what you call, principles, which are required, my dear friends, I should say, to implement international legal framework or international legal protection framework. There are many other important, what you call, principles like the guarantee the human rights of all children in the context of, migration and ensure that they are, treated as children first and foremost. So that also, requires some kind of a practical, what you call, implementation on the part of what you call of all the stakeholders, like the, provide guidance based on international law and best, what you call, practice on the operationalizations of the principles of the best interest of the child for migrant, what you call, children. But at the same time, we have to strengthen the qualified and independent guardianship mechanisms for all unaccompanied, what you call, children or separated children. We have to develop measures to ensure the non-separation of migrant families with their, what you call, children in accordance with the best interest of the, what you call, child, as it has been, initiated under the United Nations, what you call, Convention on the Rights of Child of 1989. And at the same time, my dear friends, we have to ensure the effective, provisions of the birth registration for all children in the context of, migration, and that is equally important. Now, I invite your... Yes, Mr. Ram.
Sir, actually, I had a question.
Yes, please.
Sir, it's a controversial question since nowadays this topic has been discussed going on. Sir, my question is that, like, as we know that in India, this removal of Article 370 and Article 35A happened, and sir, and we all know that the in 1990s, what happened, like with the Kashmiri Pandits at that point of time, they had to flee from there, and they resided in different parts of India, majorly in Delhi and UP and Haryana and every place where we find them. Sir, like what my conversation with the Kashmiri Pandits who saw them, who saw those things, I asked them with regard when this happened. I asked them that what is your opinion with regards to removal of Article 370? So they and what about the resettlement there now, since the government is planning to resettle them? So they said that what was the purpose of removing Article 370? Was it fulfilled? And if the government was talking about resettlement of Kashmiri Pandits, then has it been fulfilled by removing Article 370 and 35A? Like the government in power right now, they say that Kashmiri Pandits stay like refugee within their own country. And sir, my question is that sir, now they won't now, and sir, and their opinion is that even if now we are settled in different parts of the country, we do not wish to go back because now who will go there and settle again? So and sir, my question is that what is the appropriate solution then, if the government is planning to resettle them with their main objective, and the Kashmiri Pandits are now themselves are saying that what will be the purpose that will be served? So, sir, what is the solution there then?
Yeah. Thank you very much. And I appreciate I immensely acknowledge and appreciate your intervention at this stage. Your question is not controversial. Number one. Your question is not at all polemical, though there are certain polemics of a political character are involved. Your question is legitimate. Your question must be answered within the four walls of the Constitution of India. It must also, though despite the fact that we have to attend these questions within the four walls of the Constitution of India, but the question is also transcending these walls of the Constitution, and it is landing itself within the what we call, or at the anvil of international law as well. And therefore, I can say it is a multi-dimensional question. Number one, my dear friends, you should remember that abrogation of Article 370 and 35A from the Constitution of India, or Article 370 alone from the Constitution of India, we should not forget we are also having similar articles in the same Constitution, and that is the Constitution of India. And basically, because of the political overtures, because for the satisfaction of the political constituency, this kind of a step has been taken by the government of India. And ultimately, we have witnessed the abolition of this particular article, and that is Article 370. Article 370, if you see, its initial incorporation in the schematization of the Constitution of India, initially this article happens to be a robust article. Initially, this article has created some kind of a diarchy within the Constitution of India. But over the years, in the process of integration or reintegration of the Kashmiri psychology, or rather, if I am allowed to invoke the words of late Prime Minister of India, Mr. Atal Bihari Vajpayee, he was talking of the two important what he called narratives, and that is Kashmiriyat and Insaniyat. I mean the Kashmiriness and humanity. So if you take into account these two important narratives, this cycle was completed long back before the abolition of Article 370. At the time of its abolition, at the time of its abrogation, Article 370 of the Constitution of India was only of a ornamental character. It was not some kind of a barrier or some kind of a problem in the integration of Kashmiri what we call region with that of the rest of India. No, it was simply a psychological barrier, and that was propped up to what he called just to garner and just to what he called muster political supports at the hustings. That is one submission. You have got every right to disagree with me, and I am here to respect your sentiments and respect your what you call line of argument. That is one submission. Another important submission, and that is the second important component of your question, and that was, has the abrogation of Article 370 served the purpose of the resettlement of Kashmiri Pandits in their land of origin? Again, my dear friend, it is a dimensional component of your question. Multi-dimensional what we call. If you see the dynamics of the resettlement, my dear friends, you have rightly pointed out that the majority of the Kashmiri Pandits are reluctant to go back to their roots, because for the last more than 30 years or 40 years, they have been living in other parts of India, and they have, fully reintegrated with that of the local population. Economically, they feel themselves well established in their new what you call homes, and therefore they are not ready to what you call to have the transmigration. Earlier they have migrated. Now they cannot take the risk of the transmigration just to visit their roots, though their lands belong to them. Their properties are their properties in Kashmir. They can what you call sell off. They can also dispose of those very properties, and but they also make what you call or they can also rent them out, and they can also what you call mint money out of their what you call those very properties. But the larger question is, has the purpose been served, or does I mean the abrogation of Article 370 serve any kind of a purpose? For all practical reasons, my dear friends, it doesn't serve any kind of a purpose. If big industrial houses were intending to have some kind of a what you call properties, even in the persons of Article 370, they could have established their economic entities in the state of Jammu and Kashmir. Nobody was preventing them. It is basically the question of what you call of militancy. It is primarily the question of what you call of terrorism. It is primarily some other what you call issues relating to the law and order. It is basically the question of development of the Kashmir. It is basically the mainstreaming of the Kashmiri youth. It was basically a question of development as a whole of entire what you call population of Jammu and Kashmir, without any consideration of hate, without any consideration of race, without any consideration of religion, without any consideration of the political opinion. The larger what you call social milieu has been ignored. Otherwise, it was not at all required, because when it was abolished, it was not having, it was Article 370 at the time of its abolition in 2019. I think it has been on 5th of August it has been abolished. So my dear friends, at that point of a time, it was unspent force. It was simply having over the years, in 51, in 1952, in 1956, in 1957, in 1962, on many occasions, gradually this particular article was weakened by presidential orders, by certain amendments which have been carried out in the Constitution of Jammu and Kashmir. And now, at the time of its abolition, it has not been. Rather, the entire Constitution with minor modifications could have been integrated with that of the Constitution of India, while abolishing the whole Constitution of Jammu and Kashmir. There was no problem. Otherwise, today we are also having the Ranbir Penal Code that is equivalent to the Indian Penal Code. It has not been what we call, given any kind of a new shape. So by way of a mechanism, whatever the laws have been passed by the Parliament of India, same kind of laws were also re-promulgated, appropriated by the Jammu and Kashmir Legislative Assembly. So even there are Telangana is there, Andhra Pradesh is there. I mean the northeastern states are also there. Arunachal Pradesh is also there. They are also having some kind of a special status. If you go through and read all the articles of the Constitution of India, you will find. With regard to revenue, with regard to the purchasing of land, with other, even Uttarakhand in my vicinity, I hail from the western Uttar Pradesh. We cannot purchase agricultural land in the Uttarakhand. So each state is having certain important privileges. Each and every state is having some kind of a barriers. They have been maintaining their what we call independent identity in terms of culture, in terms of other important multi-layered what we call identities. Now I come to the third important observation. My dear friends, Kashmiri Pandits are internally displaced persons, and the basic and the most fundamental responsibility towards the protection of the internally displaced person lies with the national government. We have been witnessing a lot of internal displacements in this country. I am sorry, I am not at all avoiding my non-Indian students. They are the equal stakeholders as the South Asians, and we are judicially, juridically, and jurisprudentially empowered to understand and appreciate the problems of each and every geopolitical entity of the SARC, what we call grouping. And therefore, I am equally interested in understanding the problems of Bangladesh, problems of Bhutan, problems of Pakistan and Afghanistan. So you should also try to understand what exactly is transpiring in terms of internal displacement in India. We have been witnessing human displacement from their roots in the wake of the construction of the Sardar Sarovar project. Or in other words, let me put it like this: without any alternative rehabilitation, what we call mechanism, people have been uprooted and displaced. We are having Tihri Dam project that was constructed with the help of the Russian engineers and Russian engineering. I have visited prior to the construction when it was not submerged. One of my family members got very first what he call posting as a judicial magistrate in 1990, when there was no existence of the state of Uttarakhand. I am talking of the United Uttar Pradesh. At that point of time, I have visited the tunnels of the Tihri Dam project, and what kind of a what he call displacement, human displacement it has caused at that point of a time. I visited the historical monuments in Tihri, the palace of the Maharaja Tihri, the jail what he call campus. I happened to be with my cousin. I was still the student in Aligarh Muslim University at that point of a time. So I accompanied him when he was joining as a judicial magistrate. So my dear friends, rehabilitation packages do not what you call contemplate. And as a student of law, you should also what you call prepare a case study on the construction of the Jewar airport in the NCT, National Capital Territory region. How many people have been what you call displaced just to give way for the construction of an international airport in the vicinity of Delhi? Conjectrix project, Sardar Sarovar project, and other what you call big dams which have been constructed in India. How many people have been displaced for the last more than 60 years, 50 years, 40 years? People have not been rehabilitated. Try to assess the entire functioning of all the Bachao Andolans led by Medha Patkar. You can understand what exactly has been done for the rehabilitation of the people who got displaced. Because there is a fundamental right, and one of the most fundamental human right which cannot be reduced into black and white, and that is the right to have a sense of belongingness. That is not there. Right not to be displaced from their roots. This is a right which has also been propagated by Mary Robinson when she was the High Commissioner for Human Rights. She has also been the Prime Minister of Australia. She made this kind of a statement, if I am not wrong. Right not to be displaced, and right not to be poor, and right to be consulted in economic module. These were the rights which have also been presented to the IMF and World Bank when they were deciding the development package as well as the modalities, what kind of a development course a particular developing nation state must resort to. So the larger what we call picture should not be all the should not be missed, and all the dimensions, dynamics, devices, delineations must also be taken into consideration while deciding on a particular issue. So what is important is that it was basically a political move. It was the fulfillment of a very long promise made by a political party to its political constituents. Otherwise, it is important. It is important to remove all kinds of barriers, and there should be a flat what we call integration, and there should not be any kind of a special treatment to a particular territory or region. No, but this is not possible, because we believe, and it has been one of the most important asseverations since the independence in 1947. And it has been the unity in diversity. So when we are talking of from Prime Minister, first Prime Minister up to today's what we call Prime Minister, we have been what we call having the reiteration of this particular, asseveration, then we should feel that when we are, talking of unity in diversity, it means we are recognizing diversity, and there is a diversity in India. But we have to be united, and we are united. All the nation states, not only in South Asia, but beyond South Asia, they should feel themselves as united. I can give you an example, my dear friends. In 2020, Algeria has adopted a new constitution. I am not talking of South Asia. I am not talking of some other what you call, regions. I am talking a predominantly a Muslim majority state. They have adopted a new constitution. And Article 2 of the Algerian constitution, my dear friends, of 2020 is taking into consideration that Algeria will remain one and indivisible. That is the language under Article 2 of the latest Algerian constitution. So indivisibility, integrity, and integration has always been the hallmark of each and every what we call geopolitical entity. On every pretext, right to self-determination cannot be entertained. Today we are having around 200 nation states. And recently, even the Vladimir Putin has also created three new countries. Whether these countries are going to sustain or endure, because they have not been recognized by any other nation state. Out of what we call of, out of, Ukraine. So indivisibility remains the, cardinal principle of what we call of, sovereignty, because on each and every pretext, we cannot divide our, nation states. We cannot allow mushrooming of newly independent nation states. Otherwise, every individual will become a nation per se. No, that cannot be entertained. It is going to be a very preposterous argument, an absurd what you call argument, a flabbergasted argument. Therefore, it is our fundamental understanding, Mr. Om, that we should try to what you call address the larger picture of the problems of the good governance, the problems of what you call of proprietary of the public what you call offices. We should try to understand the probability of public life. These are the cardinal principles of governance, transparent governance and democratic governance. That must be ensured. And this is how the Kashmiri Pandits and this kind of a treatment should be meted out to them. The films like what we call, Kashmir Files are not going to serve any kind of a purpose. Because the ground realities must be researched. We have to be very careful. If I am addressing you and making my submissions on certain important points, I should be very responsible. I should be amenable to rectifications and rectitude. Otherwise, it will create a lot of problems. And choosing one of the more strongest what we call media platforms, and that is what we call the visual what we call media. That creates, because when we read something in black and white, it has a different threshold of impact. But when we see a movie, when we see and witness a documentary, when we witness some kind of a what we call visuals, it has, or it is going to have a cascading impact, a very an impact which goes which goes beyond our what we call our control. It is going to be embedded in our psyche, in our faculty of reason. So it is very difficult to remove those visuals from the human mind. And that is why the filmmaking, and this reminds me of such Satyajit Ray, a finest what we call filmmaker ever produced in this subcontinent. In my 11th class, I also studied a full chapter on filmmaking, and that was written by Satyajit Ray. So you can very well understand, I mean, the different, niceties, nitty gritty of, details and various, nuances. How we are going to make a presentation. Simply propping up some kind of a, political agenda and political, constituency is not going to serve the larger, what you call, I mean, larger interest of the nation state. And the people, we the people of India make this nation. And that is why we should be very transparent and accountable. And I feel that these kinds of what you call of, movies are aberrations. Because educated class like you are not going to be carried away simply by getting in some kind of a namby-pamby situation that has been, created by these kinds of, depictions. So internal displacement and Sumbul Rizvi, whom we have, invited under the webinar or seminar series of the Faculty of Legal Studies, and I have framed the topic. I have been, framing majority of the, topics for the, potential, speakers in consultation with the speakers. But it is the, beauty, intellectual beauty of the, Sumbul Rizvi. I have simply, because of what I call of my understanding, in Aligarh Muslim University, we have also invited her on earlier occasions. So I simply framed a topic on internal displacement. Let us explore to what extent we have a binding, what we call, international treaty on internal displacement, because there have been certain important principles. And these principles have been incorporated. And I do not see, my dear friends, the reflection of those principles in the law making in India, in any of the, jurisdiction of, South Asia. I do not witness that there is a reflection of 1998 UN guiding principles on internal displacement in the law making in South Asian jurisdictions. It is, my dear friends, it is in the habit of, governance institutions. They resist any kind of a, protest. Governments are reluctant to what we call, give certain rights. They are not ready to give full liberty for the enjoyment of their, fundamental rights. Governments are always in the habit of what we call of, providing and imposing restrictions, limitations, and demarcations on fundamental human freedoms and civil liberties. But it is the, citizenry, it is the stakeholders, it is the civil society, what we call, members, within the democratic, framework with a sense of, civility, they have been what we call, exercising their rights with their duties. Because exercise of right, enjoyment of rights without duties definitely create and bound to create a one-sided, society, a one-sided governance, a one-sided democracy. And we have to witness, my dear friends, a cross-fertilization of democracy and governance. This is the what we call, way out, and this is how we should reflect on issues, whether it is internal displacement, whether it is, terrorism, whether it is, issues relating to Kashmiri Pandits. Yes, I condemn, my dear friends. And I should have, condemned long back. But ever since I came to know as a student of law, particularly when I started my what we call, LLB days, I have been what we call, condemning and writing against all kinds of what we call of the human rights violations, including the human rights violations of the Kashmiri Pandits or the internally displaced, persons. Their dignity is important, their rights are important, their roots are important, and they deserve to be resettled, provided a sense of physical, mental, and psychological security. This is what I would like to submit. Any other observation?
Sir, just one more question. Sir, sorry to.
No. Please feel free.
Yes,
No, it's important.
Sir, actually, I just wanted to clear this thing. Sir, sir, the
Yes,
tribe,
please continue.
the tribal people, when the projects come, when the government makes some projects and and they give an attempt to execute it. So what happens is that various local people of that particular region, they get displaced, and they do not have homes or shelters at that point of time. So sir, can they be considered as internally displaced persons?
Reframe your argument.
Sir, what happens is that, for example, the government of India comes up with a project. For example, in Assam, state of Assam. Now, now there are certain constitutional guarantees that have been given to the tribal people in the Constitution of India. I think it's Schedule 6, I guess. Sir, and now what happens is that government comes up with a project and wants to execute it on that on the tribal lands where they have been settled, the tribal people. And now what happens is that now they have been now the government at power destructs their houses or their places of occupation, and now they are left with no residal premises. So sir, can we say that these people are internally displaced persons? Do they fit into the definition of IDP?
Yes. My dear friend, I have already answered this particular, question, but let me refresh your memory on this. That is why I have said, please reframe your argument. It has become a general practice of various, governments, and it is not true in case of government of India alone, or the state government of the state of Assam, or any other state government or provincial government. This is a tendency of a majority of the global South jurisdictions not to provide alternative mechanism or alternative model of resettlement. Nation states, particularly Asian nation states or Afro-Asian nation states, have always been in the habit of what we call dismantling, destroying, decimating the existing what we call logistical support for the survival of humanity in a particular locality in the name of development. It has become a ritual. Governments do not come with some kind of a alternative model of rehabilitation, resettlement models, or the reintegration or relocation models are not there. Such people are development induced internally displaced persons. As I along with Dr. Stalina Jolie, we have also argued climatically displaced persons, CDPs. That is a new terminology which we have coined in our book on climate refugees in South Asia. When we talk of internally displaced persons, you would be surprised, and it is very surprising to note, my dear friends, that the problems of development induced displacement that has been human displacement that has been caused because of the natural disasters or climate change, or the human displacement that has been induced by the anthropogenic interventions, These kinds of human displacements have not been addressed under 1951 UN Convention relating to the status of refugees. It has not been further addressed, my dear friends, unfortunately, under the UNFCCC, that is the United Nations Framework Convention on Climate Change of 1992. This is the beauty of only of 1998 UN Guiding Principles on Internal Displacement. Some of the principles are taking into account and trying to address your question, Mr. Om. That is the beauty of these principles. That is why I am contemplating, my dear friends, I am envisioning, and I also encourage you to come out to try to explore the feasibility of implementation, as well as the explore the normativity to have an international, what you call by internationally adopted as well as universally adopted and binding international treaty on internal displacement. Anybody who got displaced because of development, because of communal rights, because of what you call of honor killings, because of political opinion, because of membership of a particular social group, that must also be treated as internally displaced persons. Because, Mr. Om, this is my humble submission to all of you, that we are in the business of higher education. And when I'm using the word business, I'm talking in terms of philosophy, in terms of intellectualism, in terms of what you call pluralism, in terms of what you call of multiculturalism, in terms of rule of law and human rights. I'm not talking of economics. I'm not talking of finance. I'm not talking of the monetary considerations. I'm not talking of the pecuniary implications. So that should be, that is the disclaimer and note of caution from my side. So we should generate a better what you call understanding. We should explore alternatives. We should try to what you call locate the core values of human dignity. How human dignity should be what you call respected. And that has become the biggest what you call casualty in our development models and development related modalities. You can supplement my line of argument. Yeah, Ms. Sajul, would you like to say something? It has been a long, very long what you call that I must refresh your voice in my ears.
Yes, sir.
Yeah,
Actually, so
thank you very much for joining, and I formally welcome you today. Yeah.
so my laptop had not been working, so I got it repaired. That's why.
I understand. Yes. How are you? Everything
I'm
is
good,
fine?
sir. Yes, sir. Yes,
Yeah.
absolutely.
Thank you very much for your very, very soothing email. So very, very pragmatic, what we call, you understand the pragmatism of this kind of, engagement. And Mr. Om has also been, at the forefront. Both of you have been very, very affable. Yes, I immensely, what you call, acknowledge your
So I
inputs.
got so worried about like hearing about your health and also.
Yeah, that is there I am still not well because there are some issues, and my surgery has also been planned, so I'm going to have some surgery, a minor one, so inshallah
I hope it goes well, sir.
yeah, I will keep you informed. Yes, so is it okay, Mr. Rom?
Yes, sir.
Yeah, well, now I take you to another important dimension, and that is, again, as a part of the international legal protection framework, I am going to talk of global compacts. 2016 New York Declaration vision. What kind of a vision this particular declaration has come out with? My dear friends, as a part of our understanding of international legal protection framework so far refugees and migrants are concerned, and that too under international human rights law, under international refugee law, under international humanitarian law, and other important disciplines which are also having a cascading connection and creating some kind of a multidisciplinary understanding and mandate. We should try to understand the entire vision of the New York Declaration. My dear friends, the New York Declarations contain bold commitments both to address the issues we face now and to prepare the world for future challenges. When I am talking of the bold commitments, I am talking of that as a part of the vision, as a part of some epistemological and normative understanding under 2016 New York Declaration. New York Declarations promises to protect and committed to protect the human rights of all refugees and migrants, regardless of their full, equal, and meaningful participation in finding solutions. My dear friends, as a part of vision of the New York Declaration, it ensures that all refugee and migrants children are receiving education within few months of their arrival in the country of receptions, country of destination. New York Declaration, as a part of its larger what we call visionary, as a larger what we call mission, it prevents and responds to sexual and gender-based violence. And at the same time, my dear friends, it supports those countries who are rescuing, receiving, and hosting large numbers of refugees and migrants, including what we call the countries like Bangladesh. My dear friends, as a vision trajectory of New York Declaration of the 2016, it works towards ending the practice of detaining children for the purposes of determining their migration status. My dear friends, we also witness as a part of the vision of 2016 in New York Declaration that it strongly condemns xenophobia against refugees and migrants and support a global campaign, a global what we call advocacy to counter this kind of xenophobic, revanchist, nihilistic tendencies, or including what we call any kind of a narcissism that should not be what we call taken into consideration, rather it should be countered. New York Declaration also what we call strengthens the positive contributions made by migrants to economic and social developments in their host countries. And this is the novelty of the New York Declaration, that refugees for the first time, my dear friends, have been recognized under the New York Declaration not as a burden but rather as a resource. And their contributions in the nation building, or the nation building in the host country, their services, their sense of voluntarism, their strength as a resource, that must also be what we call appropriated appropriately. At the same time, New York Declarations has also envisioned to improve the delivery of humanitarian and development what we call assistance to those countries most affected, including through innovative multilateral financial solutions with the goal of closing all funding gaps. And they should also be taken into considerations. And this is the beauty of, my dear friends, of these kinds of global compacts. I mean, the global compacts which have been subsequently what we call in 2018 have been recognized, but it was one of the most important vision that whatever the gaps were there, which have been identified when the refugees were treated and branded as what we call burden. But ever since the New York Declaration was adopted, and they came out with a vision that refugees should never be what we call treated as burden, rather they should be what we call understood and treated as the responsibility of the entire what we call humanity, or any gap which is likely to be there that must be what we call bridged in terms of what we call of their resources. New York Declaration further, my dear friends, implement a compromise, a kind of a compromise that is comprehensively taken as a refugee response. based on a new what you call framework that sets out the responsibility of the member states, civil society, partners, and the UN system as a whole. Whenever there is a large movement of refugees or a protected what we call refugee situation exists, then these kinds of situations should be taken as a test case to address the grievances, refinements, and there has to be a redressal mechanism as per the vision of the New York Declaration. New York Declaration finds, my dear friends, new homes for all refugees, identified by the United Nations High Commissioner for Refugees as needing resettlement, and expand the opportunities for refugees to relocate to other what we call countries through, for example, labor mobility or education what we call schemes. And this is what, my dear friends, the government of Germany, the government of Switzerland, the government of what we call the Netherlands, and the other important particularly the government of France, they have been what we call doing. These are some of the important examples. And further, New York Declaration, my dear friends, strengthens the global governance of migration by bringing the international organizations for migration into the UN system. It is a novel what we call development. Now, international organization for migration is what we call accountable to the ECOSOC as well as to the United Nations General Assembly for its services in the field of what we call the humanitarian assistance or humanitarian what we call aid to the migrants as well as to refugees. But UNHCR remains the pivotal what we call agency, the nodal agency so far the work of what we call of assistance and humanitarian aid is concerned to refugees. There is a question, my dear friends, at this stage: what will happen next? Yes, New York Declaration and its vision is there, but what will happen after what we call some time, or of what should be the next? My dear friends, in New York Declaration also contains concrete plans for how to build on these commitments, convictions, goals, as well as other important what we call support. New York Declarations contemplates, my dear friends, that we should start negotiations leading to an international conference and the adoption of a global compact for safe, orderly, and regular migration in 2018. After adopting in 2016, it was the step that was initiated. The agreement to move towards the comprehensive framework is a momentous one. It is a very uphill task. It is going to be a humongous what we call engagement. It means that migration, like other areas of international relations, will be guided by a set of common principles and common approaches. We have to develop, my dear friends, and I would be coming to that, what we have developed. We means the international community of nation states. We have to develop certain important guidelines on the treatment of migrants in vulnerable situations, and these guidelines will be particularly important for the increasing number of unaccompanied children which have been witnessed on the move or in transition or in transit. New York Declaration intends to achieve, my dear friends, a more equitable sharing of burden and responsibility for hosting and supporting the world refugees by adopting a global compact on refugees in 2018. And it has been what we call in the month of December. I think it was the 17th, 18th, and 19th, what we call December. The 2 or 3 dates were important, upon which on this what we call D-Day, these 2018 UN what we call global compacts on refugees and migrants were adopted under the auspices of the United Nations organizations. My dear friends, let me further submit 2016 New York Declaration and the global compact on refugees and comprehensive what we call refugee responsive framework, which is popularly known as CRRF. So this is a very, very important development. My dear friends, if I put a question, what does the global compact on refugees include? The GCR, it includes, my dear my dear friends, it includes 4 important parts. Number 1 is an introduction has been provided where we find the background in the form of what we call of the guiding principles and objectives of the Global Compact on refugees. We also come across this particular framework, which is today known as the CRRF, as a part of what we call of the Global Compact on refugees, which is known as the Comprehensive Refugee Response Framework, which I have addressed in abbreviated form at CRRF. CRRF, as agreed to by the member states, has been provided in the Annexure 1st of the New York Declaration. Further, another important part that we come across, that is a program of action. Program of action where we find the adumbration of the concrete measures to help meet the objectives of the compact. And what are the arrangements we are talking of? Arrangements to share burden and responsibility through a global refugee forum. Again, we are having a new what we call institution, Global Refugee Forum. And this Global Refugee Forum, that is GRF, that has been what we call contemplated to meet every 4 years. National and regional arrangements for specific situations, and tools like funding, partnerships, and data what we call collection, and the data sharing has also been what we call contemplated under this particular mechanism, which is known as Global Refugee Forum, GRF. Then we have to again contemplate under GRF areas in need of support, from receptions and admission to meeting needs and supporting what we call commitments to solutions. We have to undertake the entire what we call peregrination of what we call solutions. Then another important part, or rather I should say the 4th part, that is the arrangements for follow-up and review, which will primarily, my dear friends, has to be conducted through the Global Refugee Forum every 4 years. An annual high-level official meeting that is held every 2 years between the forums, and the High Commissioner's what we call annual report to the General Assembly, and there has to be a follow-up and review, will also include what? The development of indicators to measure success towards the achievement of the 4 objectives of the Global Compact on refugees. This is how this entire what we call Global Compact, that is popularly known as the GCR, or you may call it the Global Compact on what we call on refugees, is going to function in this particular understanding. So, as I have mentioned, the comprehensive refugee response framework. What are the key components of this framework? This framework is also having various what we call objectives, various components. Shared global responsibility, number 1. Number 2 is the whole society approach that we should witness. It is going to support host countries. Well-founded emergency responses strategy has to be contemplated, and self-reliance. And lastly, it has to enhance durable solutions. I will explain these components in my next engagement. Thank you very much for the day, my dear friends. The day is still young. Please enjoy yourself. I am immensely grateful for your participation, and particularly for the questions which ultimately enriched our existing level of understanding what we have been deliberating. So thank you very much.
Thank you, sir. Have a nice day, sir.
Have a nice day.
Thank you, sir.
Thank you, Ms. Pathak. Thanks a lot.
Thank you, sir.
Thank you very much, Mr. Milan. Thanks a lot. Yeah. Please take care and stay blessed during these trying times. Yeah. Thank you very much.
You too, sir.
Yeah. Thanks a lot. Bye-bye.